Name?
PK Basu Lordship.
Council.
After 4 weeks, Lord.
How old is the case?
New case, Lord.
My-
Pilot
case?
24 matter.
Huh?
24 matter.
24? Huh?
Well, can it be fixed in the last week of March, man?
22 and 23.
22 and 23.
23, both right.
Learned Council, Mr.
PK Basu.
PK Basu, with the consent of the other side, has prayed for adjournment. List the matter on key ase.
Last week of March, man.
Parine? Yes. You want a date?
Date may be fixed.
22 and 23, huh?
24.
Yes,
Date is details of
24th March. Deeply obliged.
Okay.
Lordship, I am seeking listing of a matter, Your Lordship. This is the interlocutory application. Your Lordship. Last it was listed on 16/7/2025. Thereafter, it has not been listed.
Okay. What type of matter?
For continuation of delay, Your Lordship.
Condonation. When do you want?
Any date, Your Lordship.
Did you date?
May it please, Your Lordship, I am here to mention two MSc appeal, 480 of 24 and 65 of 20 for order.
Date. You want a date?
Yeah, 18 February. Yes.
Yes.
May I please, Lordship? Pray for listing, Lordship, for hearing, Lordship. Lordship, 10 to
10 to no. Not possible on 10 to. How old is the matter?
Lordship, 22 matter, Lordship.
22 matters. Common side looks on or common 17? Okay.
May I please, Your Lordship? I beg to mention for the listing of an CRP bill on the 6th of February on this week
For what?
for orders.
For orders. Fine, 6 people.
I beg to mention MSc appeal for orders, Lordship. Listing
MSc
of two
appeal for orders.
applications.
When do you want?
16th,
6th. Fine, yes, sister.
16th,
16th.
16th February.
May please, Your Lordship, with the consent of the other side, I beg to mention item number 15. My lord, it may come after 1 week, my lord. Mr. B. Chaudhary is out of station.
Learned Council, Mr. F.A. Hussain.
F.A. Hassan.
F.A. Hassan, with the consent of the other side, has prayed for adjournment. List the matter on
It may come after 1 week.
after 1 week.
Yes, ma'am. There is an interim order, my lord.
Interim order shall remain in force till the next date of listing.
May I please, Your Lordship?
With the consent of others, Lordship, I beg to mention item number 12, Lordship. Okay, matter will be taken up on 24th of February, Lord.
Learned Council,
B.
Mr.
Devi, Lordship.
B.
Devi.
B.
Devi.
Devi, with the consent of the other side, has prayed for adjournment. List the matter on.
24th
24.
February.
My lord, my name A. Iqbal may be shown. my lord.
Okay, okay. Learned Council, Mr. A. Iqbal is present on behalf of the respondent.
My name is not there in the
Respondent or the
Respondent, madam.
respondent. And his name is to be reflected in the cause list as representing the respondent.
Hearing, madam. 26th.
hearing date.
26th.
Obliged.
Earlier, interim may complete.
Interim order shall remain in force till the next date of listing.
Revoked.
May I please, Your Lordship? Lordship, I beg to pray for listing of an IA. It is for, the application is for condonation of delay. On Monday, if Your Lordship. 9th. Obliged, Lordship.
May it please, Your Lordship. Your Lordship, I beg to mention item number 1, Lordship. We have taken the consent for the other side, and the other side is also present here, Lordship. So I pray for adjournment for today as
I appear for the respondent.
Mr. N. Alan and the appearing counsel is out of station, Lordship. So I pray for adjournment for
Do you
today.
have any objection?
No, Manor.
Learned Council, Mr.
S.A. Bhakhtiar.
S.A. Bhakhtiar is present for the petitioner and is prayed for adjournment. Learned Council, Mr. B.D. Dekka is present for the caveator. List the matter. When do you want?
28th of February, Lordship.
28. 28.
20.
20.
Two.
20.
2. Much obliged.
Obliged.
My lord, I beg to mention for listing of this for motion. This is a very urgent matter.
When do you want?
Let it be tomorrow or on Friday,
On 7th Saturday?
7th.
May I please, Your Lordship, I beg to mention item number 20. I'm for the petitioner. We have filed an additional affidavit. Kindly call in for the records for this.
Learned Council, Miss.
For the petitioner, I'm for the petitioner.
Your name?
Ojasvi Gupta, O Gupta.
You Gupta on behalf of Learned
Atal
Council.
Tiwari.
Huh?
Atal Tiwari.
Mr. A. Tiwari has submitted that the petitioners have filed an affidavit.
Additional affidavit.
An additional affidavit. Post of receipt to place the affidavit on record. Learned counsel, Mr.
No.
You are present now for the respondent?
No.
No, no, okay.
Obliged.
What about the other side?
We have just filed the additional affidavit records.
Alright.
My senior will argue the
Is
case.
this matter after 1 week, Nikki? 1 week?
No, maybe I'm not seeking for an adjournment.
Oh,
just
today?
Yes.
Okay, not an
just
adjournment.
Call for
Today you, to bring it on record?
Yes.
Okay. All right.
May I please, Your Lordship, I'd like to mention item number 11 for admission. I'm appearing on behalf of the respondent. The learned counsels are out of station, so I pray for date to be fixed before the 10th of this month.
Have you taken consent from the other side?
Yes.
Learned counsel, Mr. Your name,
Benjamin Singsit. B. Singsit.
B.
Singsit, SINGSIT.
Likhila. Appearing on behalf of whom?
Respondent.
No.
Mr. S. Sahu and M.K. Ali.
Appearing on behalf of learned counsel, Mr. S. Sahu, with the consent of the other side as paid for adjournment. List the matter on when do you want?
7th or 9th of this month.
7th.
Wait, please, Your Lordship, I beg to mention an RSA. We have filed our Wakalatnama on November. On last occasion, the court has directed to issue fresh notice. We have already issued notice, so no fresh notice is required. So kindly fix this matter on 6th of this week.
On 7th.
On
7th.
Okay, so that we can record our appearance.
On 7th.
17th.
Lordship, I beg to mention item number 17. It's fixed for hearing. Lordship, I have some difficulties.
Lordship, in this case, I am for the appellant, Lordship.
I am for the claimant respondent. So, Your Lordship,
A date may be fixed, Lordship, because it's a case of 2013.
Your Lordship, Lordship can fix it on third week of February also, if diary is a
Fine, third week.
A date may be fixed, Lordship.
third or fourth.
Learned counsel.
Can it be
Mr.
9th of March, Lordship?
No, 9th is Monday,
Acha. 10th? Yes.
10th.
Learned counsel, Mr. D. Mondal is present for the respondent number 1, 2, and 4 and has paid for adjournment. Learned counsel, Ms. M. Chaudhary is present for the appellant. List this matter positively for hearing on 10/3. As this is a long pending case of 2013.
May I please, Your Lordship? I am also mentioning
obliged,
date
Lordship.
for listing. Your Lordship, in this case, the parents are the claimants, so it is also a pending case. So, Your Lordship, please can fix any date for hearing. Already, earlier it was fixed in the month of December, but it was not.
It's a long
declared.
pending case.
Long pending.
Date a reduction.
12th March. Oblige, Your Lordship. 12th March.
Aru koman agot?
No. 12th March is this or 10 March. Okay, 12th March. Oblige.
Please, Your Lordship. Lordship, I have to mention item number 11, which is already learned counsel is fixed on 7th of February, but let it be on Lordship next week, Lordship.
Oh, you taken date
Yes.
just now?
Yes, ma'am.
Let it be
Before
next-
10th. Before 10th.
Before 10.
Yes.
Next week before 10,
9,
this is for hearing?
Admission.
Yes, on 9th did you? On 9th.
Obliged, Lordship.
Your number senior is on leg in court number 3. And we pass over the matter for time only.
Okay.
Lordship.
Lordship.
Your number senior is on leg in court number 3. And we pass over the matter for time only. Okay. Lordship.
Okay.
Your number senior is on leg in court number 3. And we pass over the matter for time only. Okay.
Lordship, this is not a fit case, Lordship, because the deceased was the owner of the vehicle. So we have, as it is settled law that the owner cannot file for the death of owner, the case cannot. And it was
Yes.
already fixed for hearing. Hearing also took place at certain times. So Lordship, it can go for hearing.
Learned Counsel Ms. D. Mudumdar for the insurance company has submitted that this is not a fit case for hearing, as the deceased was the owner of the vehicle. Full stop. Hearing was also taken up earlier. Full stop. List this case for hearing on date did you?
Purana case, 2011.
12 March.
Highly obliged.
Your Lordship, this matter cannot be settled through mediation because it is not on quantum. We are challenging other grounds, Your Lordship.
For the insurance company.
And for the appellant insurance company.
Learned Counsel Miss S.
May I please, Your
A.
Lordship?
Bihani
It was earlier it was fixed on 3/4 occasion for hearing. Next, it has been fixed for mediation. It is a old pending case.
is present for the insurance company and Learned Counsel Mr. D. Mondal is present for the claimants. Full stop. It is submitted at the bar that this is that there is no element of settlement in this case. List this matter for hearing positively on
This case may be fixed in the month of February, Your Lordship.
file fees correction February. During
October
what
13
March
na?
procedure.
14.
2014 appeal, March. Obliged.
See, you have already 3 cases today lined up for hearing in
Yes,
March.
yes.
Today itself you have to start your homework.
Obliged, Your Lordship.
Wait, please, Your Lordship. Lordship, this matter cannot be settled in mediation, Lordship. I have certain grounds, Lordship, and
You're for the agriculture.
Agriculture Department, Lordship. I'm standing counsel.
Okay, Learned Standing Counsel Miss
Z Bora,
G. Bora for the agriculture department
appellant, Lordship.
has submitted that there is no element of settlement in this case, and this case may be fixed for hearing. List this case for hearing positively on date of the deduction. 12 March.
Lordship. Highly obliged.
Lordship, otherwise it is not fit case for mediation because they have also filed a cross objection against the same judgment. 2 cases in 5 itself, Lordship.
Learned Counsel Miss R. D. Muzumdar is present for the insurance company and Learned Counsel Miss
K. Burman. On behalf of P. Hazarika.
K. Borman is present for the claimants on behalf of Learned Counsel Mr. P. Hazarika. Full stop. It is submitted at the bar that this is not a fit case for settlement, and as there is no scope of settlement, list this matter for hearing positively on date 12 March.
Highly obliged.
Send it to mediation,
Lordship, it is already sent, but it is not settled.
not
So,
settled.
First, may kindly fix for hearing.
Learned Counsel Mr. A. R. Agarwal is present for the claimant, and Learned Counsel Mr. S. Dupre is present for the insurance company. Full stop. It is submitted at the bar that this case was earlier sent for mediation, but there was no settlement, and this case thus may be fixed for hearing. Full stop. List this matter for hearing on.
Next week also it possible.
No,
10th February,
not-
not possible.
Too
Then,
many cases lined up.
then
for hearing.
10th.
May I please, Your Lordship? We do not want to go for mediation, my lord. It was already fixed on hearing. Kindly maybe fix a date for hearing, my lord. It's a old pending case, my lord.
Learned Counsel Miss
SSGR, my lord.
SSGI is present for the claimants, and Learned Counsel Mr.
Is this like?
This is make appeal, no?
My lord.
AJ Sirke is present for the insurance company.
Yes.
Full stop, it is submitted at the bar that there is no element of settlement and this case will be listed for hearing. Full stop. Accordingly, list this case for hearing on data adjustment positively, for hearing positively on 12 March.
Obliged. Lordship, this matter cannot be settled.
What have-
We have
Learned
no
co-
objection. We have no objection if it's.
No, but they are not willing to settle. Learned counsel Miss
M. Saikia,
M.
Lordship.
Saikia for the insurance company has submitted that there is no element of settlement.
Let
Whereas,
me fix your lordship.
whereas learned counsel Miss
P. Bodle for K. Bhattacharjee.
P. Bodle appearing for Mr. K. Bhattacharjee, representing the respondents, has no objection if the matter is forwarded for mediation. Full stop. It appears that there is no scope of settlement, so this matter, as it appears that there is no scope of settlement, comma, so this matter is fixed for hearing positively on data adjustment.
17th March.
Obliged, Lordship.
Hopefully.
Lordship, this is not a fit case for settlement, Lordship.
I know, because you are for the insurance company.
Lordship, no,
definitely.
Lordship. There is a
Insurance
dispute regarding,
company usually say not fit for
no,
hearing.
Lordship, there is a dispute regarding policy, Lordship. And as per last order, it was
Yeah.
for hearing.
Learned counsel Mr. S.K. Sharma.
Arsham.
Mr. R. Sharma has submitted that there is no scope element of settlement in this case as the policy,
There is dispute regarding policy, Lordship.
as the policy has been disputed by the insurance company. List this matter for hearing on data review. Hearing on data review. 17 March.
Not the Lordship.
Lordships, in this case, there are two companies, New Indian United Companies. So it may be mediation.
You are for a claimant
I am for claimant.
and both are for different companies.
Different, yes.
Can we send it for mediation? You can, no? Learned counsel Mr.
S.C. Pandit.
We'll send it for mediation. S.C. Pandit is present for the claimant and learned counsel Mr. A.J. Sirkia is present for Mr. A. Acharya
For respondent number.
are present for the insurance companies. Full stop. After considering the submissions at the bar, it appears that there is an element of settlement. Full stop. So this matter is forwarded to the mediation center for an amicable settlement between both the parties, and the mediator is directed to submit a report after submit a report on the result of the mediation. Full stop. Notices may be issued to both the parties by the mediation center. Submit a report on mediation after 6 weeks. After 6 weeks, all right. Same case. Two cases are different, same case.
Same, from the same judgment,
Same-
Lordship. One against dismissal of the suit and against dismissal of the counter claim.
So there are two different cases.
Two different cases, two different appeals have been filed, Lordship.
Dismissal of suit and dismissal of counter
Counter
claim. You are the defendants in the
We
earlier
are the
case.
defendant.
Huh?
We are the defendant. No,
We'll take up which matter?
Lordship,
Which one will take up?
nothing.
Now, first?
First for just substantial question, Lordship.
Yes, which one will take up? 13? RSA,
No, same matter, Lordship, no problem.
RSA
No,
216.
both will be same substantial question, same fact, Lordship. RSA 220,
You start
220 is
with
against the suit, Lordship.
You start with your own case.
Yeah, 220 will be better. Lordship.
22 diopson. 222 diok agote. 2162 ke 222 agote diok. অলপ ওচৰত থৈ দিবচোন মই নিজে লৈ ল'ব পাৰিম অলপ ওচৰত থৈ দিম okay 220
Yes, Lordship. The plaint was at 18, Lordship. The respondents or the plaintiffs filed a suit before Munship Morigaon.
you are the
We are the defendants.
defendants.
The plaint starts at page 18, Lordship.
Mm.
Their prayer was regarding decree declaring all their rights, title, and interest,
And handing over class position.
recovery of possession, Lordship. Case was decreed in their favor. We have preferred an appeal. Initially, it was remanded back again, setting aside the judgment because no decision was made on the counterclaim. And after remand, additional issues have been framed on the counterclaim. Again decreed. Now we have preferred, and the impugned order on the first appellate court was passed, Lordship, whereby our suit was suit of the plaintiff was allowed. Our appeal was dismissed, and we have preferred the counterclaim in the WS that was also dismissed, Lordship. Our ground of appeal mainly that while passing the impugned judgment by the trial court as well as by the first appellate court, it has not considered any of the evidence laid by us, any of the documents not at all considered. Secondly, the first appellate court, Lordship, as in duty bound under 4131, have to frame a point for determination and give findings on all the issues. In the present judgment, impugned judgment, Lordship, Honorable Appellate Court, first appellate court has not decided all the issues on the counterclaim, left two issues undecided, no answer. Secondly, under 4133, being the first appellate court is the last court of facts, they have to reappreciate the evidence individually. That was not done. Here, Lordship, in the plaint.
So defense evidence was not analyzed by both the courts.
By both the courts. The facts of the case, Lordship, it was 4.5 bighas of land, out of which they claimed that 3 bighas of land were sold by one Jalal Sheikh, the predecessor in interest of the present appellants. We have disputed that those sale deeds in our counterclaim with WS.
3 bighas are from 4.5 bighas of land.
4.5 bighas
was sold by
one Jalal Sheikh, our predecessor in interest.
predecessor.
Though it was land was in the name of 3 brothers, but it is admitted by them that ultimately on mutual compromise, the land entire 4.5 bighas fallen on the share of Jalal Sheikh, and he sold 3 bighas in 1966. It was our case in the WS that no position was given ever. They have obtained mutation somewhere in 1988, 1996 that has been challenged, cancelled. Thereafter, there was a 145 proceeding filed by them, admitting that they are not in possession. We have disposed of them. In the year 1998, that case has been disposed of by declaring yes. That case was ordered that both the sides.
Mutation which was obtained by them in 1996, you have challenged.
Yes. But for the first time, they have obtained the mutation.
1966 or 1996?
1996, most probably.
And
1996.
and who has filed that attachment suit, attachment case, miscase?
I am coming on. 96, we have challenged that mutation that has been cancelled by the Revenue Appellate Court. Then in 1998, they have filed one proceeding under 145. The plaintiffs. Admitting therein that they have been dispossessed in 1998. Forcibly dispossessed. That was their case in before the 145 court. However, that 145 court somehow give the finding that both the sides are claiming possession, so I am not in a position to decide who is in possession. So I refer the parties to go to the civil court. That order was not challenged by either side, Lordship. Thereafter, they have filed the suit claiming disposition in the year 2016.
So magistrate referred parties to civil court which was not challenged by plaintiffs.
Yeah.
Hmm.
Thereafter, the civil suit pending, Lordship, as directed by that revenue code.
So in 2016, the plaintiffs filed a title suit.
Title suit, Lordship.
What is the title suit?
That is, I have referred for
Oh, God,
restoration.
okay.
That has been for declaration of the right, title, interest, recovery of possession, etc.
Yes,
In that
okay.
they have claimed to be disposed in the year 2015. We have challenged that they are never in possession. We are all along in possession.
Caveator is here.
We have raised the issue in our suit, WS, barred by limitation, but no issue was framed on that point.
Issue on limitation was raised.
Not framed, Lordship.
So let's hear a caveator.
So,
What is the substantial
just
portion
I
of-
point out, Lordship, one thing. In the impugned judgment, Lordship, appellate judgment, first appellate court judgment, which starts from page 71, Lordship.
Page 71 years.
The issues have been mentioned here, Lordship, at page 82, 81, 82. There are 8 issues in the against the counterclaim. At page 82, Lordship,
82 years.
there are 8 issues. But if we go by the judgment, at page 94, Lordship, the last findings are on additional issue number 5 and 6.
Page 84.
Page 94.
94.
And page 95 is the order part.
Okay.
There was no
two issues
mention.
were not decided. Last 2 issues were not decided.
No mention as to what happens to those 2 issues.
Okay.
Secondly, Lordship, one irregularity which I want to point out, Lordship, because it is a suit and counterclaim tried together, evidence has been recorded together. While deciding issues, the issue number 5, learned
Appellate court or trial court?
both same. Appellate court, Lordship,
We can take.
because we are in the
court
appellate
also.
judgment here, Lordship. Page 93, Lordship. Of the appellate, my appeal memo. In view of the discussions, I am of the considered opinion the learned trial court has rightly decided plaintiffs respondent are entitled to relief as per. Now let me examine the counterclaim. In issue number 5, without deciding the issues on the counterclaim, trial court has accepted the version of the plaintiff that yes, plaintiffs are entitled for relief. Then what left for the counterclaims? This shows the biasness of the trial court, first appellate court as well as the trial court. Issues, other issues of the plaintiff, yes, no problem. Court has given to find. Then on the raised by the counterclaim, normal procedure, Lordship. But trial court as well as the appellate court give the finding, yes, plaintiff is entitled for all the reliefs. Then where is the necessity of the counterclaim?
Okay. What are your questions of law?
Yes, Lordship, I have framed those at page 10, Lordship, page 14, para 10 of my appeal memo. May I read, Lordship? Whether the first appellate, page 15.
Page 15. Okay, please read.
Whether the first appellate court can decide a first appeal without formulating any point for determination as mandated
No,
under
see, this is not required. When the first appellate court decides, there is a judgment. When the first appellate court decides,
I am coming on that.
each and every issue.
That's why I am coming, Lord point, that's why.
When
That-
each and there is a judgment of the Supreme
No, that's
Court.
why I am coming. Please allow me, Lord.
Mm.
Here I have raised that all issues have not been decided.
Okay, all right.
This is apparent from the judgment, all issues have not been decided.
Okay.
So it becomes an important part, Lordship here. Secondly, formulating any point of determination mandated without making any discussion on issues framed. If we look at the first issue, 4131 has 3 points, Lordship,
Okay, all right.
3 points.
Okay.
Court has to finding on all those
Yes.
without making any decision on some of the issues framed. That is the issue number 7 and 8, Lordship.
Mm.
Secondly, whether the non-framing of issue on the point of limitation and adverse possession, we have raised this issue in the suit, WS, against their claim of, we have given some adduced evidence that in fact, they are nowhere in position, even if admitted in the judgment of this executing court, Lordship, 145 proceeding, they have admitted that in 1998, we have been dispossessed. If that being taken the date of disposition, if then also they have filed the suit in the year 2016, again claiming that we have been disposed in 2015.
2015.
A huge gap is there, 17 years. That judgment was passed in 2001. Even that is taken as a starting point of limitation, pending litigation. Okay, that date of judgment will be the starting point. Then also there is a 14 years limitation, Lordship. So we have raised this issue.
You said
Secondly,
that
whether the finding
1996, you're stating about 1996, it's
Pardon?
relating to their 145 case.
that is, we have proved, exhibited that judgment, exhibit Shaw. We have proved the judgments of the mutation orders which have been cancelled. Nothing has been discussed.
Okay, then let us admit it on those two questions of law.
My lord, some point, my lord, then your lordship will decide, my lord. Yeah, my lord, lordship kindly turn to page 82, my lord. 82, my lord, now para 17, my lord. Now let me examine each of the issues decided by the learned court below in contention raised in the appeal as well as the judgment. 82. So, my lord, from the judgment, it reveals, my lord, it reveals all the points have been decided by the appellate court also, my lord, taken into account. Only, my lord, they said, my lord, as my learned friend has raised question, my lord, page 93, issue number 5. In view of the discussion made above, I am of the considered opinion learned court has rightly decided the plaintiff in respondents are entitled for the relief as prayed for. Meaning thereby, precedent paragraph, my lord, the court has taken into account, my lord. At the conclusion, my lord, while deciding the issue number 5, because it's clearly written, my lord, in view of the above discussions. Meaning thereby, my lord, all the issues have been discussed.
Let us frame this issue.
Anyway, my lord, during my lord, he filed the appeal, my lord, and we have done our execution and we have taken our position. That lordship kindly give.
It's okay, it's okay. We can admit it, we are not staying anything.
Yes, yes.
Second position.
I am not arguing, I have their lordship, I am not arguing on that today, lordship. Because I have not get the certified copies, I have also applied. What part to the oral instruction I have only, that they have.
I have taken
suggested-
execution.
No, definitely.
I have taken into position.
That part is there, lordship, but to our instruction, lordship,
Let them try.
they have taken position, that part is there, lordship.
It's.
But
no
I don't
stay,
know-
my lord.
I don't know how far they will succeed, let them try.
Lordship,
Frame,
lordship.
frame two issues only, on limitation and on.
No,
case.
one issue, lordship, for perversity, lordship, because
No.
then one option should be given that at the time of final hearing, lordship, perversity.
My lord, this is the concurrent finding, my lordship has seen, my lord, all the
Lordship,
judgment.
unless the perversity is framed, lordship, non-discussion becomes a perversity, lordship. That's my
As
humble.
it is, I don't know
humble
how far it
submission,
will be helpful. The execution case, you have not come against the execution case.
That is not put under challenge as on date, my lord.
I don't know how far it will be helpful, but I am admitting it. Third learned counsel, Mr. Yes,
Nice to know.
Huh? Oh, ठीक है. Oh.
Oh, Sten was not good, sorry.
No, because he thought that I will read all the title suit also and title appeal also.
Yes, yes.
That is why he has left.
Lordship may pass order, Lordship, conveniently.
No.
Lordship may take up
No,
other
no.
matters, Lordship, no problem.
Later I won't have time. If I don't dictate along with the submission, I won't have time.
Yes.
My humble request, Lordship, to frame the issue of perversity, issue number 3123, Lordship.
Then it will go back to facts.
No, facts are involved, Lordship. That's why I am asking, Lordship. Not a single fact of the respondent have been
That is
discussed.
why I am framing this issue. Substantial question. It will listen. Third learned counsel, Mr. S.K. Poddar, for the
Appellant.
original defendants.
Here, appellants, Lordship, appellants
For
dependent.
the appellants, both the cases, no? For the appellants.
Same issue.
And
will be
the
covered,
learned
Lordship.
counsel, Mr. Jay Borbhia.
Lordship.
For the caveator.
Caveat.
Give it.
But you are not
Caveator.
required to be heard, but even.
My lord, no
even
matter.
recording it.
Yes, yes, yes.
This appeal is admitted on the following substantial question of law. It will very page 15 of the
14.
ABC.
page 15 RSA 220. Huh? A or B, C to nalage.
D may kindly, Lordship, at the
No,
time of hearing,
okay.
if required, Lordship.
Okay.
Because perversity issue will come, Lordship.
Sister, any other sub A to eta it will
A, B, D, Lordship, I think that will be.
A or B লিখি দিবা তার তলত D নিলিখি পেলাই এনেকে লিখিবা. Any other substantial question of law may be framed at the time of hearing the appeal. List this matter after 4 weeks.
Now we have to issue notice, Lordship, because we have added one respondent, Lordship.
Okay.
Because one of appellant, he has it Kerala or somewhere.
Issue notice here. Issue notice returnable within 4 weeks.
To the other respondents, Lordship.
Issue notice to the
Particularly.
other respondents. Number?
Respondent number, Lordship, 7. 8 and 9, Lordship. Those we have made.
7, 8 and 9.
7, 8 and 9.
7, 8 and 9 returnable within 4 weeks. List accordingly.
They are representing 1 to 6. They are representing 1
For
to
the
6.
caveator, respondent number 1 to 6.
Both
Same will be in the other appeal, Lordship.
Yes.
Same. Lordship, IA is there, it may be kept pending, Lordship.
My lord, no. IA cannot be infectious, my lord. Lordship can record, my lord, my submission.
No, because Lordship, I have.
IA, my lord, it has become infectious, my lord. I have taken position. They have to go for the appeal another. I am not required to teach them law, my lord.
So for my oral instruction, because I have not come through the certificate.
I have obtained certified copy.
Lordship.
Certified copy.
In the name of 3 Bighaj.
All, my lord, executed as part of
Let
plea.
me say, please. They have obtained possession of 3 Bigha and about 10 research.
I have লিখি দিয়া. I have লিখি দিয়া. Separate notice issue করে দিয়া.
No, my lord, that I have taken executed.
It's okay, we'll
That
issue
will
notice.
lordship do.
On the next, Lordship, if I go through the record.
Lordship only can make my submission, my lord, that I have taken already possession by way of execution. So in view of that, my lord, it becomes infectious.
It লিখি দিয়া. Learned counsel Mr. He is present and learned counsel Mr. S.I. Borbhia, S.I. no?
J.I.
J.I. Borbhia is present for the caveator and has submitted a copy, certified copy, stating that this IA is infectious as execution is complete and the
Possession has become.
defendants stroke respondent number 1 to 6 are already in possession of the suit land. Full stop. However, issue notice to the other respondents.
May I take back my lord certificate copy?
Oh, you'll take it back?
Yes.
Okay.
Or I'll supply one photocopy to the court.
A photocopy of the certified copy will be furnished by the caveator.
My lord.
All right, Lord.
Had he called for the records from the trial court as well as the appellate court?
Appellate court.
Please, Lordship, my senior is on legs on C7. Can the matter be passed over for the time being?
Time being, yes, can be passed. Oh,
Okay.
you are also here.
I am for the respondent, my lord.
Okay, okay. Item number kiman kole?
16, Lordship.
No, my lord, I think there's a problem, your lordship kindly see.
Given 16 percent.
Page 11, my lord. Page 11. of the memo appeal, page 11, my lord,
Page 11.
page 11.
What kind of problem?
Yes, it's judgment, my lord.
My judgment.
My lord. That's why I'm pointing out. Maybe, your lordship kindly see that I, none other than
Oh,
lordship. My lord, my lord. So,
Dibrugarh.
Dibrugarh.
What?
my lord.
I cannot pick up. I cannot pick up. This is my
Okay,
judgment.
yes.
You've come in appeal against my judgment.
So anyway, my lord, your lordship kindly, any other answer?
That too, about 23 years ago.
My lord.
I cannot pick up.
Lordship.
Correctly shown.
No, my lord, yesterday when I was preparing, all of a sudden when I have seen your lordship name,
Then you
immediately I
didn't
stopped it. Immediately I stopped it. man.
Use
Deep
this matter before any other court without me. মোৰ নামটো লিখি দিবা, হা?
Deep left.
Parties are represented, they will লিখি দিবা, হা?
May I please, Your Lordship? My senior counsel Peter is just coming. I just
18, item number 18?
yes, my lord.
Okay.
Just call him. He was lagging in another
বেলেগ
one.
এটা দি দিয়া, তেওঁ আহক, আহি থাকক। নাইনটিন নাইটো এইটোতো হেৰি কৰি দিব পাৰি, বেলেগ এটা ডেট দি দিব পাৰি, 19 না? Both the parties are not represented today. List this matter for hearing positively on the next week. Positively on next week. After 1 week, লিখি দিয়া। List this matter for hearing positively after 1 week. আৰু 20 দি দিয়া। 20 to কিবা হেৰি affidavit দিছিলে ৰেকৰ্ডত অহা নাই বুলি কৈছে না? Somebody has submitted that you have submitted an affidavit which is not on record, additional affidavit.
I don't know about
You don't know. 20 to থাকক দিয়া, এইটো time being দিয়া। 21? 21 will take up. Appellant is present, will take up 21. What about the other side? Respondent?
Yeah.
21, respondent's name is also not shown. Doesn't show 21 to keyhole. লাহে লাহে কৰা mix up হৈ যাব নহলে
Here, 11, 12, 24 order.
Yes, yes.
2 and 3 notice is deemed as served. The 11 to 24, 2 and 3. Regarding 1, it was whited. Then Lazima court's orders say has to report. Then respondent number 1's sister refused to take notice. 2 and 3 already earlier refused. So 1's sister, he has also refused. So as regards the service of notice upon respondents, it should be presumed as served upon all.
This is always coming back to me.
Now, Jiten Bhengra, his sister has refused. 2 and 3 personally has refused. And only one his sister is refused. So, I think all should be presumed as served.
LCR দিলে নেকি? নাই দিয়া ন? এইটো LCR নহয়। হেৰি দিব ন কজ লিষ্টত চোৱাচোন। নাই, অ'কে। Learned Counsel Mr. Emily Mahmood is present. This appeal has already been admitted for hearing, but the records of the appellate court as well as the records of the trial court is not before us. Call for the records from the appellate court and from the respective appellate court and the trial court list after receipt of records. We'll need the record.
Yes, but, as regards service, that should be.
It's already there.
Already there.
Already there. It's it has been listed for hearing.
Yes. All right. If it one আছিল. Item 24. Timing asile. Oh, I see.
Yes. Okay, we didn't have that.
Affidavit.
Now
Yes,
the
that is
affidavit
school matter.
on
Yes,
record.
yes, sir.
Okay. The school, what do you want? What do you want the name of the school to be changed?
My lord, they have filed affidavit. In their affidavit, if your lordship kindly go to the last annexure of their affidavit, that is page 81.
Page 81.
Yes.
Hmm.
We have also filed reply to some action. This we have supported, kindly see. It is their affidavit. To the headmaster in charge, B.R. Miller High School, Bhukuapeta. Lordship has seen?
Yes. B.R.
Bhukuapeta.
Miller High School, Bhukuapeta, yes.
This is our case.
Hmm.
Regarding mention full school address in the signboard and other official papers in respect of your school. Now can you see second para?
Okay.
Second para. Therefore, you are instructed to mention the full address of the school in the signboard and other official papers in respect of your school, that is name of school, name of village, name of post office, name of district, pin code, etc.
It is name of post office, yes.
So, this is very important matter. It is their affidavit and they say, now let me show some facts of the case. Kindly see page 17 of my CRP. Page 17.
70 or 17?
17 of my CRP.
Yes.
Here, B.R. Milan High School, Bhukuapeta. Does you have seen?
Yes.
So, it is there that is that we have annexed this, and that they have also supported this. This is the letter which I have just read. That was annexed in our CRP.
Same letter.
Same letter.
Mm.
So we have a case which they have supported through their annexure. Now kindly see page 18 onwards. 18 onwards. 18 first see. High School Living Certificate Examination 2014. School's name B.R. Milan High School, Bhukuapeta, Rauli. Lordship has seen.
Mm.
In 2014 mark sheet,
Mm.
the name of the
Yes.
school is B.R. Milan High School, Bhukuapeta,
Mm.
Rauli.
Mm.
Our case was that, my lord, the school, B.R. Milan High School, is situated at village Bhukuapeta. And the circle officer has also certified that the school is situated at village Bhukuapeta. And this is clearly also stated in 2014, the B.R. Milan High School, Bhukuapeta, Aravalli. So we have no objection on it. Then kindly see page 19.
Okay.
This is Board of Secondary Education. Name of the school, B.R. Milan High School, Bhukuapeta, Aravalli. Lordship has seen?
Yes.
Page 19.
Mm.
Then page 20.
So, is there a dispute only with the word Rauli?
No, Bhukuapeta.
With the word Bhukuapeta?
Bhukuapeta.
Okay.
So here also we see page 18 onwards. In all papers I have up to page up to page 30. This Google has also published a kindly see page 26.
Mm.
B.R. Milan High School, dash code number so, date of establishment so and so. Page 27 is the relevant portion. B.R. Milan High School, Bhukuapeta. Page 27,
Mm.
top left side.
Mm. Yes. Okay.
And the IAS, after due inquiry, so these are all these things are from Google. It is we have taken, and all these are there.
Fanখন অকমান দি দিব পাৰি নেকি বাৰু?
Now,
এক নম্বৰ মোৰখন। এক নম্বৰ। Page what? Which page you are showing?
based from page 18 to 31.
Yes.
All the papers say Bhukuapeta, B.R. Milan High School, Bhukuapeta, Rauli.
Mm.
Now there was a meeting, public meeting,
Mm.
that may be seen page 33. Its contents were also forwarded to IS.
Mm.
On behalf of Village Development Committee, kindly say,
Mm.
I would like to inform you that B.R. Milan Higher Secondary, now it is Higher Secondary,
Mm.
converted, upgraded, has not been changed. Only the name of Bhukuapeta village has been added to the address of the school, which has already been done as per the order of the Inspector of Schools, Borpeta District. So I would like to inform you that Bhukuapeta Milan Vidyapit Middle English School and 738 Bhukuapeta Primary School have been amalgamated, and the school is not under the Bauli Village Development Committee. So there is LPME school, there is Middle English School, and there is also primary school, middle school. All schools' name there is Bhukuapeta. So this public filed a petition that the school should be named as B.R. Milan High School, Bhukuapeta, Post Office Ravli. But a section of the people, now even the IS made some inquiry into the case. Kindly see page 17 of my, that I have already read, my lord, page 17. So here it is clearly stated that the village name should be incorporated. So that is there. Now kindly see the certificate of the circle officer. Page 37.
Okay,
Page 37A.
okay. 37A
Yes.
or B.
Of the CRP.
37A is a picture.
No, no, no. 37A.
37B, circle officer.
B is the vernacular. A is the type
No, no,
copy.
no. 37B, 37A is a picture of the school and 37B is the certificate of the circle officer.
So if you read the
Certificate?
certificate,
Yes.
kindly say,
Hmm.
the circle officer has issued প্রমাণপত্র দেয়া হল যে হরক্ষেত্রী মৌজার অন্তর্গত ফুকুয়াটেপা গাঁৱৰ 30 নম্বৰ মেধিপাট্টাৰ 353 নম্বৰ দাগৰ 2 বিঘা 4 কাঠা 7 লেচা মাটিত B.R. মিলন হাইস্কুলৰ নামত আছে আৰু উক্ত মাটিত বিদ্যালয়খন অৱস্থিত। এই প্ৰমাণপত্ৰ সংশ্লিষ্ট লাটমণ্ডল সুকাৰ প্ৰতিবেদনৰ উপৰত ভিত্তি কৰি দিয়া হ'ল। Now, the circle officer, who is the grassroots level officer of the place, he has clearly stated that nearly 3 bighas. 2 bighas, 4
bighas.
bighas, 7 less, means
Almost 3 bighas.
3 bighas. So, the school is situated at village Bhukuapeta. But it was sensed that B.R. Milan High School, Post Office Ravli. Where it is situated?
Ravli.
They say. They say, mean I don't know how they have motivated. When the schools is situated in Bhukuapeta village, where is the objection? Ravli would be there. Ravli, Post Office Ravli, we have no objection. But they have changed the signboard into B.R. Milan High School, comma, Post Office Ravli.
So this is their objection.
They have done this. Our submission is that B.R. Milan High School, Bhukuapeta, Post Office Ravli, District Borpeta, Assam. The very
Objection
simple-
by the school authority or by government?
Inspector of Schools, Lordship.
So I do not understand. Well, it's a very simple matter. Where the school is situated, they do not want to hear people's sentiment are there. The school is situated in our village, but our village name is not there. B.R. Milan High School, Post Office Ravli. What is this? What is it? Where is the school situated? Who is in which village?
They do not want to include Bhukuapeta.
No,
Ravli.
I know it is earlier. It was there. Much earlier in the year 76. That papers we do not have, but thereafter for a long time, admit card, school certificate, Google, and this circle officer everywhere. B.R. Milan High School, Bhukuapeta.
You have agreed by which letter? You have come against which letter? Which order?
Eh,
I'll come back after 5
yes,
minutes.
yes.
Yeah, isa niki?
Our order is
Come back after 5 minutes.
impune order page 16.
I'll come back after 5 minutes.
Letters. Kindly see page 16 of our CRP.
You are agreed by this letter,
Agreed by the 16.
page 60.
Yes, 16.
Impugned letter.
Yes.
So you have prayed to quash this letter or something?
Yes, yes. That should be set aside. There are two things also. There is a civil case was filed, but I am not pressing on that. I am not pressing on that. I am only in the name of the school, that is the apple of discord. So, page 16 can you see? It is dated 14/11/25. to the headmaster in charge, B.R. Milan High School. Now kindly see B.R. Milan High School, this Bhukua Tepa, Napeta, Bhukua Tepa. Bhukua Tepa village is not found here. And he write inquiry report. He refers the inquiry report that I constituted. IS says I have
Where? Headmaster of B.R. Milan High School, Bhukwa Tepa.
page 16.
Yes, 16.
Yes.
B.R. Milan High School, no Bhukwa Tepa here.
Yes, that is the headmaster in charge, B.R. Milan High School, top left side. Here, in this letter, this Bhukwa Tepa village is not there.
Where? There's no Bhukwa Tepa in the letter.
No, that is not there. This is our objection. 14/11/25, this has been done, but before on few months back, and I am coming to that matter later on. Now kindly see, regarding school address in signboard and other official papers in respect of B.R. Milan High School. So Bhukwa Tepa is not here. Then he constituted an inquiry committee as per director's direction, and the committee submitted a report. Then the IS says,
Page 16, you are talking about page 16.
16.
Where is the word Bhukwa Tepa? I cannot find.
That is not there. That is,
Oh, it is not there. Okay.
that is not there. That is our case.
Bhukwa Tepa or Bhukwa Peta?
Bhukwa Tepa. No?
Bhukwa Tepa.
Bhukwa Tepa. Bhukwa Tepa. My name is peculiar name. Sometimes if I forget. So, here, Bhukwa Tepa. Now kindly see third para. Under the above circumstances, the inquiry committee recommended that in the interest of public, the school name be remain unchanged. That is B.R. Milan High School, Post Office Road.
Bhukwa Peta should not be there.
Here he says that
But you
public
want
interest.
name Bhukwa Peta to be
Yes. Now,
inserted.
before that, this order, before it was filed on 14/11/25 by this letter. But now kindly see page 17. Next page. The headmaster in charge, B.R. Milan High School, Bhukwa Tepa. Here is here. It is dated 17/4/25. Last you have seen. So here, Bhukwa Tepa is here. So lastly, the last paragraph says, therefore you are instructed to mention the full address of the school in the signboard and other official papers in respect of your schools, that is name of school, name of village, name of post office, name of district. This name of village, everything is there, name of village is not there. Post office, we have no objection. So here it says in the interest of public. What is the interest? Is it public interest? I am surprised that the school is situated at village Bhukwa Tepa, and Bhukwa Tepa word has been omitted. And the IS says in the interest of public. What is the interest of public? Now let us refer to their affidavit. What they filed in affidavit. Page 79 can you see?
Page 79.
Was 79. 79, Roman 3. Lordship has seen?
Yes.
There is no public interest involved in change the name of the school. So, there he says, there the inspector of school BGC says that there is no public it is passed in public interest. Lordship, can you see his stand? His or her?
His.
His. So, Lordship, in that play he says that this name has been changed, in other words, changed as D.R. Milan High School, Post Office Ravli. That is done in the interest of public. But the same officer's inquiry committee said that there is no public interest involved in to change the name of the school. Quite contrary statement, conflicting statement by the responsible government servant.
Okay.
And most important thing is this, inquiry report, my lord, inquiry committee was constituted. But who are the members of the inquiry committee? When they filed affidavit, then only we came to know. Before that, we did not know that there is an inquiry committee. So, copy should have been furnished to us. Number one. Second thing is most important, that is the inquiry report. Now, inquiry report, my lord, it is the principle of law that if some order is passed, which may be affected otherwise or which may be injurious or objectionable to some person, then copy of the inquiry report should be furnished to other party. Lordship knows this very well. If a public servant is going to be terminated, he must be given a notice, he should be given, then inquiry committee, maybe constituted inquiry committee will
This is not
submit.
termination of public servant.
My lord?
This is not termination of public servant.
Now, inquiry report was not furnished to us. Now, the Honorable Supreme Court says that I am giving the judgment.
Citation?
Citation, this is, my lord, this is 1990 INSC. 1991. That it will be, INSC, it will be difficult, that kindly say 1991, 1991, 1 SCC 588.
Party's name?
Party's name, my lord, Union of India and others
Yes.
versus Muhammad Ramzan Khan.
Okay.
Now, here the Honorable Supreme Court says, para 18, we make it clear that wherever there has been an inquiry officer and he has furnished a report to the disciplinary authority at the conclusion of the inquiry, holding the delinquent guilty of all or any of charges with proposal for any particular punishment or not, the delinquent is entitled to a copy of such report and will also be entitled to make a representation against it if he so desires, and non-furnishing of the report, this is very important, and non-furnishing of the report would amount to violation of rules of national justice and make the final order liable to be challenged hereafter. So, when there is a dispute between group of people, now director constitutes the inquiry committee. Who are the members of the inquiry committee? We don't know. We have come only to know about from their affidavit. When they filed affidavit, then we came to know that there was an inquiry committee. This first one. Second one is this. What is the report that is not furnished to us?
Yes.
And the impugned order has been passed. The Honorable Supreme Court says the other party is entitled to get the report. So in that view, my lord, entire case appears to be either politically motivated or for personal vendetta, because there is no public interest. The inquiry committee has also said no public interest. Then why you change the name when the school is at my village? So by oral submissions, my lord, by oral submission, an illegal thing cannot be made legal. So they may say, we have done this in public. Who are public? Public says our village name should be there. There may be 1 or 2 persons, that is another matter. But what is on record? On record, it is clear that nearly 3 bighas of land, the B.R. Milan High School, Bhukuatepa, is situated, and this school is situated at village Bhukuatepa. So when there is record, and when there are so many communications, and where the IS himself repeatedly said name of the village should be included, all on a sudden passed the impugn order that I have said impugn order, and that is page 16. 17, page 17 is in our favor, say it is write the name of the village. But in page 16 you will see, he has said it will be B.R. Milan High School, Post Office. No village. Where it is situated, that is not there.
Because here,
So their oral submission and legal position of law, that if something is done, inquiry committee or inquiry report, all these things should be given. The Supreme Court has said, in a case of our High Court, Shah Alam Lashkar, in WBC number 7474,
7474.
oh yes, oblique 2022, date of order 22/3/2023. 22, that means 22 March 2023.
Okay, and the party's name?
Party's name is Shah Alam Lashkar versus State of Assam.
Okay.
Here also in para 12 and 13, it is said, it was regarding license was cancelled without furnishing the inquiry committee inquiry report to the license holder. So that was, even then the order was passed cancelling the license. The Honorable High Court, our High Court says no, as the copy of the inquiry report is not furnished to him, so cancelling the license is illegal, and that was set aside.
So we have the respondent number 4 before us. And what about respondent number 1, 2, and 3?
Lordship, I'm for respondent number 1, 2, and 4, and for 3.
You are for 1, 3. Okay. You can place your submission.
Lordship. Lordship, coming to page number 17 of the petition. Lordship, this document has been relied by the petitioner, Lordship. Dated 17th of April 2025, where the headmaster, where the inspector of school had communicated to the headmaster of B.R. Milan High School that an allegation was received by few villagers, public of Bhukuatepa, that regarding the name of the school along with the address and all everything. This was the first document. This is not the final document as relied by my senior friend, advocate, Lordship. Lordship, coming to Lordship, the inquiry report. After this communication was made, Lordship, an inquiry was set up by the inspector of schools, consisting of two persons, Lordship. That is the Lordship. Maybe please to come to page number 77 of my affidavit, Lordship. Consisting of the Deputy Commissioner of Schools, Borpeta, and Block Elementary Education Officer, Senga Block, Senga. An inquiry committee was constituted to verify whether the name should be Bhukuatepa or Rauli or simply B.R. Milan School, Lordship. There was no intention or any pressure or any political pressure, Lordship, in constituting the name of the school, Lordship. An inquiry committee was constituted having these two authorities, Lordship. As per the inquiry committee, Lordship, an inquiry report was submitted, Lordship, on 21st of October 2025. Lordship, may be pleased to come to page number 78 of the affidavit of petition. Coming to the first report of the detailed report, Lordship. Serial number 1, BR, that is Bhukuatepa Rauli Milan High School. Milan, which means
both should be in harmony, not fighting for the name of the place. B.R. Milan High School was established in the year 1976 and classes commence on such and such date at the campus of Bhopkatapa Milan Vidyapit Middle English School. Later, SMC, that is School Management Committee, purchased 4 bighas of land from Satyanath Sharma, who also donated an additional 2 bighas for the school. In the meantime, Rauli Public donated 7 bighas of land where the school currently operates. The school is situated in Bhopkatapa Revenue Village, and details provided. And the school was provincialized in the year 1972. From this, we can see that 4 bighas of land plus 2 bighas, which is 6 bighas, came from public of Bhopkatapa, and 7 bighas of land came from the public of Rauli. This is a secondary issue, Lordship. Coming to Lordship, point number 4 of this report, Lordship. A meeting of SMDC and the public of Bhopkatapa and Rauli was held on 30th of March 2025 to discuss the application submitted by the Bhopkatapa public, but no decision was reached. As coming to point number 5, Lordship, the Bhopkatapa public has requested that the school signboard and other documents include the village name, that is B.R. Milan High School, Village Bhopkatapa, Post Office Rauli, District Borpeta, PIN 781311. On the other hand, Lordship, the Rauli public maintains that since the school was established as B.R. Milan High School, Post Office Rauli, District Borpeta, established in the year 1976 and now has completed 50 years of successfully under this name, Lordship. That from this we can see that, Lordship, we can come to 2 conclusions. Firstly, the name of the school was B.R. Milan High School, Post Office Rauli, District Borpeta, established in the year 1976. From 1976 till date, the name is B.R. Milan High School, Post Office Rauli. The name Bhopkatapa village is not indicated, Lordship, in the name as per records, Lordship. And second, Lordship, conclusion we can come that, Lordship, it is a fight between the public of Bhopkatapa and public of Rauli, Lordship. Lordship, there is nothing to do with it is between both the parties, Lordship, both the villages, Lordship. And since the name was in the name of Rauli, Lordship, no Bhopkatapa was written in the signboard, the inspector of schools, along with this report, Lordship, as inquiry report, Lordship, we find that there is no provision or there is no situation has arisen that the name should be changed from B.R. Milan High School, Post Office Rauli to B.R. Milan High School, Village Bhopkatapa, Post Office Rauli, because the name should be uniform since the date of establishment, Lordship, since 1976, Lordship. These are the, Lordship, detailed report, and Lordship, coming to the conclusion, observations of this report, Lordship. The first observation is that the school established in the year 1976 has successfully completed 50 years under the name B.R. Milan High School, Post Office Rauli, District Borpeta, established 1976. This is the first observation. The name should be maintained. It should not be either Bhopkatapa or Rauli, Lordship. The name itself has 2 names, Bhopkatapa, Rauli, Milan High School. There should not be any dispute whether it should be Bhopkatapa or Rauli, as the name has been, as it has completed already 50 years since its establishment, Lordship. And coming to the second point, that is the name appeared in all the school testimonials, that is school certificates, board registration certificate, mark sheets and other documents until 17/4/2025. The name should remain same. That is as per the Inspector of Schools, as per the records of the Inspector of Schools, it should be B.R. Milan High School, and also all the school
So you are,
testimonials.
just a moment, this letter, you are agreed by the letter dated 17/4/2025. But here this inspection report, inquiry report is of 21 October 2025. So where is the scope to furnish you a copy of the inquiry committee? There's no scope, I think.
No, that means when we have filed this case, at that time, we had we have not been served this report. Then when my learned friend, inquiry report, I am saying about
Inquiry was held after your case was filed. You will not get the inquiry committee report then. Now you will get because an affidavit has been filed.
Yes, from their affidavit we have come.
So these judgments won't, the judgments, these are not applicable in this case. Supreme Court judgment and our court judgment.
So far regarding report, if it is prepared after filing the case, then necessarily we do not
So you do not have a
have
case
the
now.
right.
Let me dismiss it.
But apart from that, what compelled them to change the name? My learned friend has forgotten that since 50
No, see,
years.
whatever your argument is, it relates to the after effect of the inquiry. See, the public and all they are agreed, whatever the decision, whatever the letter, I think I will dismiss it. No point going ahead.
No, what is the interest in changing the name? My learned friend says since last 50 years,
Otherwise, you
but
will
I have annexed
file an affidavit. You cannot conclude now.
regarding inquiry report.
Yeah. We cannot conclude now. The case, everything is going on.
No, in
We
our,
agreed by the order.
in our affidavit
That
in
is
reply,
in the submission initially stated, this is only the, this is not a final decision. This was initially the letter was issued and now decisions have been taken and then you are submitting some judgments which we cannot take into consideration because inquiry is going on. Initially, before the inquiry was going on.
no, it is final order. It is final order.
No. See, you are agreed by 16. Page 16.
Yes.
This is 17.4.
Lordship, page 16.
And then you are referring to inquiry committee and you have submitted 2 judgments and I have heard you for half an hour only on those 2 judgments. And that too, that was inquiry committee report was submitted on October. This is on April and inquiry committee report was submitted on October.
Kindly see page 16. Here it is final order. As it appears from the order, the committee recommended
But
that.
she has submitted that this is not a final order.
Lordship, I had addressed page number 17, Lordship.
17, okay.
Lordship, this is page number 16, Lordship, 14th of November 2025.
Okay.
This is the conclusion of the report, Lordship.
Okay. This is the conclusion.
Yes, Lordship. And the report was concluded, and Lordship, it was mentioned in this letter that after the report of the after the inquiry report, the name should be
All
clear.
right.
It is final order.
This is the final order, Lordship.
Final.
Page number 16 is final order, 17 is not final order.
That 17 is the initial order, which the petitioner relate.
But our case is that.
Okay, I got your point.
Yes. Now regarding inquiry report, we have mentioned in our affidavit in reply that we have
It's
got
okay,
the
it's
inquiry
okay.
report.
You can continue.
Lordship, coming to the judgments shown by my learned senior advocate, Lordship, both the judgments are not applicable in this present case. Lordship, the first judgment shown by the Supreme Court judgment, Lordship, it is for cases of Lordship second show cause notice, Lordship, not for an inquiry of a village or a community at large, Lordship. It is a service matter, Lordship, not for civil disputes, Lordship, not for disputes of facts and all, Lordship. So first judgment is not applicable, and coming to the second judgment. Even the Lordship, the second judgment, Lordship is not applicable in the present case, Lordship. Lordship, for personal vendetta of 2 villages, Lordship, the name cannot be shown. And secondly, an inquiry report cannot be distributed at public at large, Lordship. They cannot expect that all the villagers should get one copy of the inquiry report, Lordship.
We are not all, we are SMDC.
And Lordship, and it was mentioned here, Lordship, in the final order, and Lordship, internal communication, Lordship, inquiry cannot be distributed at public at large, and if required, they could have filed an Lordship, representation or Lordship, Lordship, we could have filed a representation, Lordship, for demanding the Lordship authorities, Lordship. And Lordship, coming to the conclusion that this, and coming to disputed facts, Lordship, I think Lordship, if required, Lordship may remand back the matter to the civil court to verify whether the facts are correct or not. Because all the facts shown by the petitioners are disputed, and from our inquiry report, it is concluded that the name is B.R. Milan High School, Post Office Rauli, since last 50 years, Lordship. We did not make any change, and we have no intention to make any change for any dispute between two villages, Lordship. Lordship, that is my conclusion, Lordship.
Well, two replies.
You want to say something?
No, Lordship, I'm appearing on behalf of SSA. Lordship, we have got no role to play. Yeah. Okay.
Two replies.
Okay.
My learned friend has said, since last 50 years, this name is going on. It is not true. Because we have annexed many documents, Lordship has seen. We have annexed so many documents from page 18 onwards, that B.R. Milan High School at Pukwatepa. So, continuously last 50 years till today, it is absolutely incorrect.
What is your civil case about?
Civil case was
You come against the order
for
of civil
seeking
court?
injunction,
For what?
and that the name
It shall continue.
earlier name should be continued, and then it should not be changed. But that has been written on the ground of 80, section 80, within bracket 2 of CPC, because as
So
they
we
go,
remand it back then, complete the formalities, it was CPC kon diya, sir. After you complete the formalities, it may be taken up.
Lordship, though I have got no role to play, but it seems it's a dispute between two villagers.
Yes, two
And
villages,
they
yes.
fighting between the two villagers. Ultimately, Lordship will have to take into consideration the school, the students are affected. It's a fight only between the two villages, Lordship.
And both the villages have donated land.
Donated the land,
Yes.
Lordship.
So we'll send it back.
well, that maybe, but our submission is that it may go
Let's see
back.
the civil courts order.
Civil
which
court
you
has
have-
returned.
Huh?
Civil court has returned the case.
Oh, rejected.
Returned,
Okay, returned.
not rejected.
Let's see.
That is order page 60. It starts, and lastly it ends in page 62. Page 62, para 11. Return the plaint to the plaintiff. Page 62. The Seshadar is directed to return the court fee deposited by the plaintiff.
So this order has been correctly passed. You know case lies. I'll dismiss it. No case lies, actually. You can take the cause of action from today, from the date of dismissal, and then you can file and then issue notice to under section 1.
No, the title suit, we shall have to file appropriate petition. That was not there. That was the reason.
So I'm dismissing it. The plaint has been correctly returned.
No, plaint, we are at present, we are not on the plaint. That may be done, but
No,
what
no,
was
but
the
if
is-
you're not on the plaint, how can you file a revision petition?
No, we have challenged that order. We have challenged that order.
No, but the order has to have some basis. You have challenged the order before the civil court.
Yes.
Then you have come against the order of the civil court. You do not have a case here.
Against the order of the civil court,
You have come against the order of the civil court, which has been correctly passed, and then I'll pass an order rejecting your CRP. Then how will that, any order lie against that, page number 16? No order will lie against page number 16. Page number 16, that originates from the order of the plaintiff.
Yes, 14/11/25, and the
It originates from the order of the
civil
plaintiff.
court's order is 21/11/25.
You see, I do not find any case. I do not find any case, honestly.
But thing is this, why?
No.
What is the reason of changing the name?
Mr. H. Buragohai's unwell lordship, he has requested me to adjourn the matter for today, lordship.
Mr. Buragohai is not well. You have any objection?
The 24th. Only my consent is there, will that may not be recorded.
No, I won't. I won't record your consent. Item number 18.
24th February, madam.
Okay. 24th February? Fine, 24th February hearing lo bola.
It's a Tuesday.
Tuesday. No, because you see, we have too many cases fixed on the hearing dates. Some other day? Fine, 24 di bola?
Matter of 2014, madam. Huh? March will be too late because it's a matter of 2014, my lord. Landlord tenancy more than 12 years in High Court.
No, okay. I'll fix it on 24th. Learned Counsel, your name?
P. Sharma.
Miss P. Sharma, on behalf of Learned Counsel, Mr.
H. Buragohai.
H. Buragohai has prayed for adjournment as the Learned Counsel, Mr. H. Buragohai is unwell. Host of Learned Counsel, Mr. P.K. Roy Chaudhary is present for the respondent number. How many?
All the respondents.
For the respondents. Full stop, leads this matter for hearing positively on 24th. Okay.
Much obliged.
Item 19 is 19.
We have already passed an order in item number 19.
My counsel was there.
I'm simultaneously said.
It was called out.
So, and he was there, my lord. For the
No, he wasn't there.
18,
It was
19.
called out.
18, 19 both were there.
Same name.
So
Oh,
that
18
cannot,
and 19, non-PS question. He was not there.
my lord, 19, my mind, your
18.
lordship, my lord, your lordship will, this is second appeal.
No, we will hear you.
My
Now
lord,
you are here, we'll hear you.
because, my lord, the issue is simple. Second appeal only on the point that in the 114,
What the other side?
my lord, they are not willing and I am suffering.
19 to sound. Just a moment.
9 again. When
Nine and-
18 was there, my lord, he appeared. Next item 19, how could he go away, my lord?
No, he was not there. 18, 19, both the cases.
9 again. He was not there.
Maybe he was there in 18, maybe.
The next item was 19, my lord. He cannot go away immediately, my lord.
Maybe he didn't hear when it was called out.
This is also a 2018 matter. Second appeal, obtaining a stay order, only substantial question of law, a circle officer's report, which was not rebutted by the other side.
18 to লৈ আনাচোন কি বা অৰ্ডাৰ কৰা হ'ল আছে ন 18
This is 19, my lord.
কোন আছিলে তুমি কেনসেল কৰি দিব ক'বা অৰ্ডাৰ কিটা 18 আৰু 19 দুইটা কেনসেল কৰি দিব ক'বা কোন আছিলে
Even just now 18 has been done, my lord.
Okay, 18.
So this is 19.
18 to এইমাত্ৰ অৰ্ডাৰ দিলো নেকি
This is 19.
One last chance. He was not there. He was present in the last date.
My lord, if next occasion, if he is not,
I'll bring it on record.
that if he is not on the next day, it may be.
I'll bring it on record. Appellant is not represented today. Learned Counsel Mr. P.K. Roy Chaudhary is present for the respondent.
My lord, I am all the respondents, ma'am.
For the respondents and has submitted that. The appellant is being highly prejudiced owing to
Appellant, not my lord, I am the respondent here.
Okay. Learned counsel for the appellant is
Absent.
No, appellant is not represented today. Learned counsel for the respondent, Mr. P.K. Roy Chaudhary is present. and has submitted that the respondents are highly prejudiced owing to the long pendency and procrastination of this appeal. Full stop. Considering the submissions by the learned counsel for the respondent, for my last opportunity is accorded to the appellants. Full stop. List this matter for hearing positively on data DDA.
Maybe the same day, 24th, if they are not.
24th February. Full stop. On failure of appearance of the appellant on the next date fixed, necessary order may be passed. So that day we will dismiss it.
Well,
Although it is RSA will dismiss it.
well, all right.
When this case, my lord, IA has been filed right now, my lord. The copy has been served to me, my lord. I will file objection and kindly fix a short date, my lord. So for maintenance.
Is O Gupta, on behalf of Learned Counsel, Mr. A. Tiwari has submitted that an objection has been filed.
No, my lord. They have filed an IA, my lord. It is-
An IA has been filed. Learned Counsel, Mr. P. J. Sotia submitted that he will file objection in the against the IA. This matter on data deduction. March of the
My lord, it will do too long, my lord. Maintenance, my lord. I am the wife, my lord, not getting any maintenance from the petitioner, my lord, since 2022, my lord. Despite order being passed.
Not possible.
Last week, my lord, February, my lord. And
Not possible.
so small matter, my lord. The petition is not maintainable, my lord.
So accommodate tinta din baki ase, another 3 days left
My lord.
to accommodate in the
My lord,
month of February.
From next Saturday onwards, my lord, Saturday.
Saturday did you par?
Yes.
21st, 25th
Yes.
February.
Saturday is my lord, the bench open, my lord.
Saturdays we can hear for people
Yes.
who are willing to come. Many are not willing to come.
Yeah.
If you're willing to come, we can hear.
21st, no? Oblige.
Please, your lordship. But I found a decision of the Supreme Court, which is very clearly spelled out that this amendment would be retrospective. I have to, lordship, produce a book.
Oh, that
because-
day we heard heard the argument
Yes,
that
Lord.
case, no?
Lordship.
Okay.
The issue that day was whether
argument dito আছে no? Lagato আছে. ঠিক আছে.
this accident had occurred, lordship, prior to the amendment. The dispute that day was whether the new amendment would be applicable to the accidents which occurred prior to the amendment.
New amendment will be?
Whether the
Amendment of?
new amendment, which
This
is
accident occurred before the amendment of?
amendment of section 163A, which is now
In which year, which year?
It was in the 2018. Accident was in 2000.
Amendment of for 2018.
2018.
Accident occurred before the amendment of 2018.
Yes, lordship. It came into effect in.
And the issue was
Lordship?
whether section 163?
Yes, lordship. Section
What was the issue?
163A.
Huh?
Amendment was on 22/5/2018. And
Issue was?
in this case, the accident had occurred prior to the accident because
And the issue was whether the amendment of?
163A.
Whether the amendment of 163A will be
applicable to accident which had occurred prior to the amendment.
163A. 163A become now 164.
So it has become 164.
164 will be applicable. Applicable, what was the question?
Retrospectively.
For cases which occurred before 2018.
Before the amendment. In this case, the accident occurred on 21/7/2014.
Before which occurred before 2018.
18.
Before 5/2018.
22/5/2018.
Okay.
In this
So
case, the
according to
accident had
which
occurred on
years?
21/7/2014.
According to years, you have a judgment.
Yes, lordship. There are various judgments, but Supreme Court has sealed the issue. There is a very long judgment of the Calcutta High Court, which has been agreed to, lordship. I could not find it in the software. Yes.
2000, how much? What is the citation?
Citation is 2025.
2025?
So I could not find it in my software also.
Okay, it's okay. 2025 is.
New India Assurance Company versus Urmila Haldar.
44. Two 2025 ACJ 244, okay?
Yes, 244.
New India Assurance.
Company versus Urmila Haldar. So our High Court has decided that they had given my that judgment, Vijaya Bhuya.
Vijaya Bhuya, you have given me the judgment.
That judgment is enough, fine, Your Lordship. I had given the judgment, Your Lordship said you would.
And our High Court judgment?
Yeah.
Vijaya Bhuya.
Vijaya Bhuya, I'll have the citation.
Okay, I don't have in the record. I've sent it back, I think.
Vijaya Bhuya.
Nine. Vijaya
I've
Bhuya.
given it that day. It's there.
Vijaya Bhuya?
I still have it. I still have a copy.
Okay, nine.
National Insurance Company versus Vijaya Bhuya, 2019 STPL.
I'll keep this book with me
Yes, sir. I'll take it back.
afterwards, after my judgment. Yes. Please give me the High Court judgment.
In that case, our High Court judgment as well as the Calcutta High Court judgment, Lordship. That's a very extensive judgment. My Lord Dipankar Datta, as he was then at that,
Then
he
High
was
Court
in
judge.
Calcutta High Court when he
Yes.
decided, Dipankar Datta.
Vijaya Bhuya.
That's Guwahati.
And you have given me this.
Yes, I have given that.
Urmila Haldar, you have given me.
Did I give that day?
Oh, Calcutta High Court, okay.
Calcutta High Court.
This is now by Sandeep Mehta. The one you have given me is by Sandeep Mehta. Supreme
That's
Court.
by Dipankar Datta and Sandeep Mehta.
Yes,
244 page.
242, no?
244.
The tag it on my way. 244 is.
This is Dipankar.
No, no. Asanuddin.
Yes, that is Calcutta High Court. He was that was Dipankar Datta.
Upheld, I
Yes.
think.
At that time, my Lord Dipankar Datta was in Calcutta High Court. So that was the main issue, whether
Okay. So it has been held, and so this High Court also must follow suit as the Supreme Court has held.
Lordship. What the Supreme Court has said in the judgment by Lefebvre and I'm not aware, Lordship. The thing is that on the last occasion, Lordship, the question arose only is whether the amendment provision of 163, now which is 164, would work as a retrospective effect or prospectively. So my submission was it will be prospective, and there is very much lots of judgment is there, Lordship, regarding the applicability of new amendment provision, Lordship. So first is that, Lordship, it was 2009, Supreme Lordship 1194.
You see, you go through the judgment, what he has stated.
So, Lordship,
submitted.
if my
Your
lord can read out the
paragraph-
provision, Lordship. Lordship?
What are your paragraph number?
Lordship, I have numbered the paragraphs in that Calcutta High Court judgment. That has been, Lordship, agreed to
And
by
this,
the
our Guwahati High
Guwahati High Court judgment, Lordship. I've given both the copies. Guwahati High Court judgment copy, Lordship. I have the copy, printout copy, Lordship. Here, up to paragraph number 25, Lordship, it was fine. After 25, Lordship, the learned as a single judge.
You please mark with the paragraphs here.
Yes,
Hello,
yes.
PDF.
But Lordship, this is the latest judgment of the I have Supreme
also
Court on the issue. I'll complete my argument, Lordship. Normally, Lordship, in Urmila Haldar's that Calcutta decision, it is a very big decision that is discussed. I have numbered the paragraphs, Lordship. It's very clear. Normally, the rule is that all substantive laws will apply prospectively. There are various factors when that can also be used. But procedural
retrospective.
rules apply retrospectively. It's a procedural rule. Procedural rules apply retrospectively. Lordship, I also relied on the judgment that given the judgment of Supreme Court is Jile Singh. That is very clearly distinguished. This is also taken in Urmila Haldar.
Jile Singh.
Jile Singh, Lordship, is there mentioned in the I'll give a copy also. Jile Singh. That there. Jile Singh is very that word.
The paragraphs also.
Jile Singh, Lordship.
I'd given a right with that day, it's there, the thing I'll give a copy now. Just
This
This is judgment on the, basically on the word substitution as a technique of bringing in amendments. And what is the impact of that? That is discussed in this Urmila Haldar's decision, that's the Calcutta High Court. That is discussed Jile Singh.
Jile Singh.
Jile Singh, this is the judgment. It's basically primarily focused on the significance of a word substitution while bringing in an amendment. So
Okay.
what is significance of substitution when an amendment is made? It's basically on that only. It's just like the old rule did not exist, it's replaced by entirely a new law.
What is the paragraph? Which paragraph?
That thing, I'll mark the paragraphs and give it to you after this.
Yes, yes, because it will be very difficult.
Yes, I'll sit
You
here
see,
for 5 minutes and mark the judgment.
So many judgments to rely on. At least I have to read at least 4, 5 judgments.
Jile
every
Singh's
day.
also,
And if you don't mark
given,
with the paragraph, it becomes very
I've given a write-up like this there, and Jile Singh's paragraphs are also there. I'd quoted it.
Write up. You have
That
given
is
a
there, I've given this particular part. It's there, para number 24, 25.
write up.
Yes, yes, it's there. I've given this. That
You
also
have
this-
given a written argument, I believe.
No, it's not a written. I had given this amendment also. This particular page would be there. Lordship may see this. There are the paragraphs. I have reproduced the paragraphs of Jile Singh.
मोटू देखा मैं या देखूं. Oh, everything you have submitted has been misplaced. I'm sorry. It's not here.
Lordship, I'm giving this part again. Lordship, all these paragraphs Jile Singh.
It was not.
It will be there.
এখন. Now I've got.
Lordship, if this is the page, then paragraphs of Jile Singh is reproduced here. Paragraph 24, 25. There is also under decision of Karnataka High Court that has also discussed on this particular line only the techniques of amendment.
Yes, I have got it. You can take back the Jile Singh. Oh, no. Yeah, it's only in the write-up, no?
It's an item and I can give the copy also.
Whether you have given the heading is whether the amendment of section 163A is retrospective in nature.
Is it?
Okay.
Is it?
I've got the write-up.
Apart from that, my argument was based on substitution.
Jile Singh
But-
দুটা আছে, এটা
but-
verify.
Supreme Court has also relied on the procedural. Since these are amendments are procedural, this will apply.
Okay.
And the paragraph, Calcutta High Court says whether one likes it or not, that will apply. Whether it might be sometimes what has happened is in our case, Guwahati High Court case, that 16 lakhs something was brought down to 5 lakhs. In these cases, these have been brought revised upwards. One judgment was for 1,57,000. That is in made 5 lakhs. Another was for 143. That was made 5 lakhs. This under judgment of the Calcutta High Court recent also. It has relied on this again Supreme Court judgment. Same lordship.
You want that amount to be reduced?
This is amount needs to be 5 lakhs as
How
per
much? 5 lakhs.
5 lakhs as per
That is the fixed amount.
fixed amount. And lordship may see.
And this has been notified also.
This is notified.
So when you see MP Act has been amended, but so many sections have not been notified.
Yes, sir.
Yeah.
This has been notified.
This has been notified.
This is notified. It's there in the judgment itself that when.
So, it's okay.
Lordship, I'll mark the paragraphs immediately after this year is over.
Yes.
Okay.
Mm.
Yeah, lordship.
You want to reply on this?
Lordship, there are other aspects of this case also. One aspect is that in that case, 2,25,000 was given under the head of loss of consortium, then loss of love and affection again, then loss of love and affection to the claimant number 1 due to death. This has been given twice to the same claimant wife, once for 1 lakh, once 25,000. So under all these heads, lordship, my submission is that now as per Pranay, even if lordship will see that Supreme Court has not taken future prospects or other things into consideration. But this,
Pranay Sati, that last paragraph, no 40 or something.
yes, Lati,
That,
it will apply here because although
Please give me the paragraph of Pranay Sati.
paragraph, lordship, I'm not serious. That's why I'll.
I know it is in the last part of the.
Last part,
document,
yes.
But I have forgotten the paragraph.
It's there, and even Pranay is there. Because that's the practice used to be earlier. Now this learned tribunal, learned tribunal at that point of time had relied on some judgment of the Supreme Court to give this 1 lakh as a time. But
Pranay
Pranay
Sethi came in 2000,
17.
17, no?
Yeah,
and
all
his
the
judgment
judgments
was-
that Pranay Sethi took into consideration all the judgments.
Earlier judgments.
Yeah,
yes.
which are giving 1,50,000, etc. Now it was just streamlined the whole thing, put a cap on that vertical cap 40,000,
40,000.
and there's no horizontal proliferation either way, even anywhere. But it's also provided for 10% increase after every 3 years.
After every 3 years.
So
yes.
this, I think, has to be followed. Pranay Sethi is being followed even there also. So wherever their interpretation of the Supreme Court that apply retrospectively. In this case,
So this 2,25,000 is like 1 lakh.
it will
for
like
the
1
wife.
lakh 2 minor children. So 120 it will be. 120 plus 10%, it will be 120. It will be.
It has to be 120.
120 only because the
10%
judgment year.
increase after every 3 years.
Yes, ma'am.
40,000 into 3.
Yes, that's lordship, and section 164 does not provide for this. It's all
yes,
inclusive.
yes.
Funeral expenses, pain and suffering is all inclusive, lordship.
Section 164 does not provide.
Provide for all. It's just a blanket state way of it. Does not say that he'll pay more than this.
It is only fixed amount.
It is a fixed amount, 5 lakhs.
For this was loss of consortium
Loss of consortium.
and filial and parental consortium.
Yes, yes, all these heads.
Mm. So this new section does not provide.
This section does not.
Only 5 lakhs. Only
Yes.
5 lakhs fixed.
And also loss of love and affection, I leave it to your lordship, because although there is no year, I leave it to your lordship to decide.
Okay.
Love and consortium, etc. But it should, if it is decided, it should be as per Pranay Sethi. It's not like 1 lakh, etc.
So you see, when there is a judgment of the Supreme Court, you cannot leave it to me. I'll have to abide by the judgment of the Supreme Court.
No, no, sir,
Love and affection and consortium, I'll have to abide by the decision of the Supreme Court only.
They did not clearly
You
say
want,
anything.
you want
Why I'm saying this, lordship?
Other day or today you will complete.
Lordship.
That's up to if lordship is otherwise busy, lordship.
I'm not busy.
Then
I can
yes,
hear you.
Yes.
I can hear you.
Why I had said that this I leave it to lordship?
No, because I'm
not-
saying because he has brought 2 new judgments today. If you want to reply today, you can reply.
His judgment from his submission was what I have understand lordship. His judgment is to the different aspect. My learned friend is submitting that regarding the applicability of new amendment prospectively when the law is only procedural law. Now my submission would be whether 163 is a procedural law or a substantive law. Supreme Court has very much clearly stated that it is a substantive law, not a procedural law. That cannot be superseded by any other law. Even there is a non-obstantive clause who clearly stated that any other law, including that cannot override the section 163. It is very much substantive law, not a procedural.
Where is it written?
No, see, I'm giving that.
It's
So
not just, I'm just adding on, not just procedural law,
yes.
there are also word substitution. The
What
way
word
it has come about,
Yes, I'll-
even that cannot be changed. It is brought about by substitution, and Supreme Court is there in Gile Singh. Gile Singh, it says substitution. When something comes by way of substitution, it applies to all, as if the previous law did not agree.
That is also I'm saying the last judgment lordship my learned friend relied upon regarding this High Court judgment of this Bijoy Bhuya. Up to paragraph 2025, it was fine. After 25, paragraph number 25, in 26 lordship, the learned single judge has said that since it is a procedural law, so that can be lordship applied as a retrospective effect. So this is the lordship. Perhaps lordship was mistake committed by learned lordship single judge at the time of passing this order, because the 163
paragraph.
Lordship, paragraph number 25, lordship.
Bijay Bhuya
Yes,
judgment.
Bijay Bhuya judgment, lordship. Up to paragraph number 25, lordship is okay. Paragraph number 26 is relevant, lordship.
After paragraph 26.
Yes.
That the single judge has committed error.
Yes, lordship. Because regarding the prospective and retrospective, that has been settled by the learned single judge also, lordship, up to paragraph 25. Regarding the procedural law and substantive law, that has been, lordship, perhaps lordship committed a little mistake, lordship.
Okay.
Lordship. So in paragraph number this, if Lordship allow me to read paragraph 26. The question therefore needs to be considered whether the amendment relate to merely a procedural matter or whether the application of the amendment second schedule is pending proceeding would affect vested right of any of the parties. So this line is very much important. If Lordship give to it retrospective effect, then my client will be very much prejudiced because her vested right would go up to Lordship limiting 5 lakhs. And this is not a merely to procedural matter. So section 166 is not a merely a procedural matter, Lordship. Section 140 is a procedural matter because this is a no-fault liability. But 163 is not a no-fault liability. In 163A, Lordship, here the defense side has the option to, Lordship, refute the evidence of the claimant to nullify his claim. So this is not a, Lordship, a mere procedure. It is a substantive law. And regarding this this line, that line at single judge has held, it is only procedural law. Because I am relying to judgment, Lordship.
So according
Yes.
to you, section 163A is
Not a procedural law, it is substantive law.
is not procedural and substantive and can be refuted.
Yes.
Like
Can be
section
refuted. Line
166.
166, yes. The 2025 judgment, Lordship, I am giving 2025. Yes.
2025?
Yes. 2025 Supreme SC 1139.
25 Supreme SC
1139.
Yes, sir.
I think I'm reading.
2025. There should be one number also after
Yes.
25.
It is judgment.
2025 Supreme
Ah,
within bracket SC 1139.
2025. Okay.
So just reading, Lordship, paragraph number 15 at internal page number 6.
Para 15.
Lordship.
So now you see Zile Singh you have given.
Zile Singh might be, Lordship, regarding if the law is the procedural, that can be, Lordship, give retrospective effect.
Then say Zile says the amendment.
Otherwise, yes.
Not-
Amendment,
Zile
yes,
Singh does
amendment.
not say where is
Regarding
procedural
procedure.
certain.
Then
It just says when the amendment is brought about by substitution.
Substitution.
This
let
is
both the, Lordship, judgment be discussed, Lordship.
Zile Singh judgment has been discussed here.
No, I'm not saying that. If my learners.
Paragraph has been judgment discussed in Urmila Haldar by
Yes.
Calcutta High Court.
Whether that is why I'm saying, Lordship, let my learned friend read out the paragraph, relevant paragraph, to make the law clear, Lordship. At this stage, otherwise,
Please
Lordship,
read out the paragraph.
yes, which
Which
paragraph,
on that Urmila Haldar's case, I'll read out the paragraph.
whether the procedural law.
That
is
judgment may be
substantive law.
given back to me. I'll just read out the paragraph.
You do not have another copy?
So it's a big judgment. I had only one copy, Lord. So I thought I had given that day.
ইয়াত আছে নেকি কেনেবাকে উৰ্মিলা হালদাৰ এই যে এটা কম্পাইলেশ্যন এটা দিছিলে তাত আছে নেকি কেনেবাকে
Lordship, only issue that
Right up to-
required to be decided is whether, Lordship, 163 is a procedural law or substantive law.
No, the other issues also to be decided. That's not the only one issue.
And my learned friend has to be confined, Lordship, within his pleadings only. What is his grounds of Lordship in appeal?
Whether I plead rightly, wrongly,
Yes.
no, it's law.
কোৱাচোন উৰ্মিলা হালদাৰ ডাউনলোড কৰা let him download otherwise I won't be able to follow whatever you are reading.
Then, Lordship, may take up in next week, Lordship. I also, Lordship, go through whether this law will applicable in this Zile Singh judgment.
Okay, we can fix it on next week.
Lordship.
Because you see,
Whether, Lordship, only question is whether it is a procedural law or substantive law.
No, apart
okay,
from
we
that, whether
এটা
it's-
download কৰি দি দিয়া
Apart from that, yes, whether
That's
it can be.
not the only issue. That whether it's a, whether,
you want a downloaded copy of this?
no, so I'll
Okay, then, okay. নালাগে দিয়া
I'll mark the paragraphs myself. The paragraphs are marked here also. Lordship, it's
paragraphs
in
are
the-
marked, yes.
Yes, I'll keep a copy.
May note it down, Lordship, the number. Okay.
Yes, yes, এই লোৱা
You can say, hey, judgment and unproven Wakia action.
see both are two bench judgments, huh?
Lordship. Regarding, Lordship,
Urmila Haldar and then this
Yes.
your
this is, Lordship, Calcutta High Court judgment.
Wakia Afrin.
Yes, this is High Court judgment, not a Supreme Court judgment.
No, no,
This one, Urmila Haldar.
no, no. There's a
That has been
Yes.
ratified by Supreme Court.
Then
Regarding-
upheld by Supreme Court in another.
Another judgment.
Lordship,
You
two-
give him the judgment of the Supreme Court.
Yes, it's a book only. I could not find. I have to download it. It's not there in any of the softwares.
It has been upheld by the Supreme Court.
Yes, Lordship.
I'll give you it. Take down the citation.
Lordship.
Two 2025 SC or ASJ.
ACJ 244.
ACJ 244, New India Assurance Company versus Urmila Haldar.
Urmila Haldar.
And which are the paragraphs here?
The paragraphs are here 8, 9, 10.
You read it and come. This is not Calcutta High Court judgment, this is Supreme Court. Para 8, 9, 10, 10. এই জাজমেন্টবোৰ এই ফাৰ্ষ্ট ফাইলটো ৰাখিলে ভাল হ'ব, ৰাইট আপ জাজমেন্ট গোটেইবোৰ দেই। কি তাৰিখ আজি? 3 February না? 26. এই লিখাচোন, Learned Counsel Mr. R. Goswami is present for the appellant and Learned Counsel Mr. J. Kolte is present for the respondent. List this matter on. We will form a new law.
Lordship,
After
because
hearing it.
that is why I am saying, Lordship, in the morning
We
also I am
formulate a new law then.
yes. In the morning also, I thought that if Lordship go by this judgment, then definitely I had a Lordship concept to refer the matter in larger bench regarding this Bijay judgment. So because this is not a
It's not
substantive.
required to refer to larger.
Yes.
Decided by
That's-
Supreme Court.
yes.
Only interpretation is required.
Yes.
So interpretation by this court is required.
Lordship.
If I am wrong, then I don't know.
No, no.
And if
that's-
I'm right, maybe later.
No, Lordship, regarding that, only that judgment, Lordship. On last occasion, Lordship, this was argued only on that.
This is very interesting.
Yes, Lordship.
That's it will
So
be very.
because on that day also, Lordship, I am very much vehemently settled that law is settled that any new amendment has to be given prospectively. It cannot be retrospective unless otherwise there is a.
This is what we believe.
Yes.
But he has brought out a new word substitution.
That I am sure, Lordship, that very much sure there's a loss of judgment, Lordship. Might be there is something different in facts. In
Let's
Halder
see,
case.
yes.
Lordship, I will clarify it on the next.
But Calcutta High Court has very deeply gone into all the aspects my learned friend has raised.
Yes.
It is
This
there.
is what we believe. What he is submitting and what you're submitting is what we believe.
Yes, Lordship. Calcutta
But
High
by
Court
the
has
word
said that this is the
substitution,
standard method.
Let's see.
Prospective application is the standard.
We'll give a good hearing
Yes.
next week. ভাল খালি date এটা দি দিয়া। On 17.
17, Lordship.
আৰু বেলেগ ডেট নিদিবা সেইদিনাখন, অলপ মেটাৰটো হেৰি আছে, কমপ্লিকেটেড হয়। বেলেগ আৰু বেলেগৰ জাজমেন্ট নিদিবা, মিক্স আপ হৈ গ'লে দিগদাৰ হ'ব। বেলেগৰ হিয়াৰিং নিদিবা সেইদিনাখন, মানা কৰিবা দেই। বেলেগৰ হা মানা কৰি দিবা সেইদিনাখন দিবলৈ। তাৰ পিছদিনাখন দিলে হৈ যাব। শনিবাৰ নহয় জানো 17? Saturday?
Tuesday, 17 is Tuesday.
Tuesday.
On Saturday, I think nobody wants to come, no, on Saturday. So not.
I have some law court practice also, I have no issue also. Because I have some law court practice also, so I have no issue. It's
Tuesday
just that
better.
also.
No, but here many people, they do not want to come on
Yes, my
Saturday.
language-
We have to come, so we will adjust accordingly.
Yes.
Those who want to
Now
come, can
notification
come.
has come up. Lordship.
Do you want to come on Saturday? Then we'll.
No, I will have it on Tuesday.
Tuesday.
17
No
is
issue.
17 Tuesday.
Tuesday.
How much?
All right.